because the commentary falls outside the zone of ambiguity. But secondly,
Well,
what is abundantly...
let me just mention that both the Third and the Ninth Circuit have found that the term large was indeed ambiguous.
Yes, Your Honor, that's true. In both Trumbull and McIntosh, those courts in the Ninth and the Third Circuits did indeed address this question of ambiguity.
Well, ma'am, we don't have to get to that. Let's do some bullet counting. There are 31 bullets, the prosecution says. Probation says 32. Two 15-round magazines. Listen to this scenario. You put one bullet in the chamber, you pack it with a 15-round magazine, that's 16 bullets. You got another magazine, that's 15. That adds up to 31 bullets the prosecution got. So how do we get to an extended magazine?
Your Honor, yes, indeed, that is the problem here. The court has identified the issue. The PSR on page 162 of the joint appendix has the only information contained in this record related to the nature of the firearm and the magazines that were found here. And the problem I think Your Honor has identified is that this information is very vague and unclear as to how the magazines were filled, where the ammunition was located, and whether or not, as Your Honor has pointed out...
Was there a finding with respect to the number of rounds?
Your Honor, the only thing that is located in the PSR is what Judge Floyd has identified, which is that the magazines and firearm contained a total of 32 rounds of 9mm ammunition.
All right, well, if it contained 32 rounds, then one of those rounds must be 15.
But there's a, you gotta get this right first. The prosecution had 31 bullets. That's in the statement upon which the plea was taken. Then you get the PSR, and then all of a sudden the bullet count goes from 31 to 32. Now, he pled guilty on a set of facts that there were 31 bullets. So that's the problem in this case.
Yes, Judge Floyd, you're correct. In the PSR on page 77, which is the factual basis that the court has identified, it does very clearly say 31 rounds of 9mm ammunition recovered from the magazine.
Excuse me, counsel.
Yes, Your Honor.
I thought that the PSR had made a finding, or that there was a 32 rounds finding in the PSR.
Yes, Judge Wilkinson, that is correct.
All right, then the question is, was there an objection raised to the PSR about that particular finding?
No, Your Honor. There was no objection that was raised here.
So the district court adopted the PSR without objection.
That is correct, Your Honor.
So does not that 32 round finding is part of an unobjected to PSR, and I don't recall even in a briefing up here that that issue about the 32, about the finding, was raised. Was it raised in the briefs?
Your Honor, we noted what the facts were in our brief, and we noted that the application of this guideline would not be appropriate here.
No, that's too general. Was there the problem is we're not only up here on a single plain error question, we're on a double plain error. We're on the fact that no objection was made to the PSR initially, and then the question was not raised with any degree of specificity in the briefing. So we have a double PSR to start off with. And if there's anything that's crucial to federal sentencing, it is that if there's no objection to the PSR, the district court can adopt it. And why that would seem to me to be pretty much conclusive, and the reason is that the whole idea of objections to the PSR is crucial to sentencing. We can't do attorneys' work for them. And ultimately, it redounds to the detriment of defendants if attorneys are given the leeway to say, well, you don't need to object because the Court of Appeals will pull it out for you. And that's not good. It's unfair to district courts, and it undermines the adversary process when we have an unobjected to PSR that makes a finding and leaves the defendant with the burden of somehow saying the finding was wrong, which I'm not sure has been carried. But that's initially a problem, is that the need to object and the importance of PSRs and the allowance given to district courts to adopt them. That's a problem for you, is it not?
I understand the court's point, and it is well taken at this point in time. We did not object, that's correct, at the district court level. This question wasn't presented for the district court to analyze. However, this court has the ability to consider what we're arguing now, which the court should have.
Mr. Reese, might I just add, I think I can reconcile this for you if we just slow down for a second. I think the statement of facts only spoke, if you look at the statement of facts, it speaks only of the magazine. It says the magazine in the car and the magazine in the firearm total 31. But then the PSR, as Judge Wilkinson said, which was not objected to, says 32 because it says the magazines and the firearm. So the reason that, as a humble district judge sitting here, you do what you need. And what was needed for the statement of facts for the enhancement was just speaking in terms of the magazines. The PSR, though, added the bullet that's in the firearm. So the difference between they can be read together. They're not inconsistent, in my view. It's just the statement of facts spoke only in terms of magazines, while the PSR says magazines and firearm. And if that's true, doesn't that give us enough bullets? Because that means at least one of the magazines had 16. Isn't that correct?
Your Honor, I don't disagree with that court's analysis, but I think that part of the problem with where we are at this stage is that we're now interpreting and viewing evidence that really isn't very clear. I do appreciate the court's point.
I'm going to read you the statement of facts. It said the 31 rounds of 9mm ammunition recovered from the magazine in the car and the magazine in the firearm. Doesn't mention a firearm. But the PSR then speaks about the magazine and the firearm. The difference simply between the statement of facts and the PSR is the and firearm, which is the additional bullet. That leaves you with the 31 between the two magazines. So one of the magazines had at least 16, which means the enhancement applies. Isn't that correct?
Your Honor, I agree with your math. The only part of that analysis that I would raise a question to is whether or not the magazine in the car actually could suffice for this enhancement. Because if we turn to the language of this enhancement with the base offense level, and assuming for the sake of argument that this court then looks at the commentary, this court then has to make an analysis about whether or not it was in close proximity to that.
Aren't you making an argument, the points you're making, aren't those very same points? Ones that should be, this whole argument should be had before the district court. Should it not? This is not the right venue to be having this whole discussion. This should have been held before the district court. And I might add that the 15 figure, which we're dealing with here, seems to me to be very generous to defendants, because a lot of the states have much stricter requirements for their enhancements. A number of them have a requirement of 10 rounds. Others are, it seems to me, much harder on defendants than this particular figure was. But this particular figure is very important because the number of rounds that a magazine is able to carry bears directly on the ability of people to undertake mass shootings and mass executions. And so society has an interest, and the Sentencing Commission has an interest in putting some lid on the amount that somebody who might be contemplating a mass shooting can have. Is a very important societal interest in not expanding this 15 figure or playing fast and loose with it.
Yes,
Ms.
Your Honor.
Ms. Reese, let me ask you this question. We're talking about an extended magazine, not bullets. So if you go to the commentary or you stick with the statute, what evidence in the record is that there is an extended magazine? It doesn't matter whether 31 or 32 bullets. The question is there evidence in the record that there is an extended magazine? And is there?
Your Honor, our position would be no. I would say that based in the PSR, the only information that we have is this singular statement that the magazines and firearm contained a total round of 32 rounds of 9mm ammunition, to the court's point. And I would say, Your Honors, if we're going to go back a little bit to even how we're conducting this analysis, whether or not we apply and we determine that it is ambiguous, the question then becomes, are we applying the guideline as it has been written, which basically says a semi-automatic firearm that's capable of accepting a large capacity magazine? So I think in the scenario where we're talking about here, we have a firearm under Judge Novak's analysis that has 15 rounds in the magazine and then 1 in the chamber. So is that really a firearm that is capable of accepting a large capacity magazine? There's no analysis about that.
I think you missed my math there. I'm sorry, I must not have been clear. I think my math is 15 plus 16 equals 31 of the 2 magazines with 1 in the firearm. And I think that is the discrepancy between the two, the statement of facts. So if 16 means, if there's 16 rounds in 1, that of course means it is acceptable. And while we're talking about rounds, what the guideline says is it accepting of at least 15? There's been no, at least I'm not aware of any testimony that was put forth that talked about you could have held 20 or 30. We're only counting the rounds because if you got 16 rounds, it's capable of 15, right? So.
Respectfully, Your Honor, if we're going to look at the commentary doesn't say 15, it says more than 15.
Well, that's 15 is more than 15. Am I not right about that?
You are correct, Your Honor. And I think the point that I was making is really if we're talking about the firearm here, that's what the guideline is asking this court any court to analyze. It says it's about the nature of the firearm and the capability of what it can accept. So if that's the standard, looking at the PSR, there's just simply not enough information for a court to make that finding. I would say, Your Honors, regardless of whether or not we have ambiguity in the first part of this analysis under the text.
You say part of the firearm, but the part of what this enhancement is getting at is magazines that are not necessarily inserted into the firearm, but are proximate to it. And if they're more than 15 rounds, or 15 or more rounds proximate to the firearm, that's part of what the enhancement is getting at. It's not just whether it's inserted into the firearm or part of the firearm, but a lot of it is also proximity. Because that underscores the ability of someone to undertake a mass shooting.
Yes, certainly, Your Honor, in the commentary part B of the second application note, there is that proximity language. But if this court is going to apply the Kaiser v. Wilkie analysis, determine that the guideline is ambiguous, and then look to the commentary, part of that analysis is whether or not the commentary fits with the guideline itself. And if we're looking specifically at Part B expands the scope of the guideline because the guideline text itself has to do with the gun. It has to do with the capabilities of the gun. Part B can be read to say that this base offense level enhancement could apply if there's just a magazine that has more than 15 rounds in it nearby. That is far beyond the scope. I think, Judge Wilkinson, to your point, which is that the intent of this guideline was to target and punish those people who have firearms that could, impose serious damage and pose a danger to people. The way this commentary is written under Part B, it would expand it so that someone could be punished for this if just a magazine that didn't even fit the firearm was found nearby. And it fit that more than 15 language.
Well, let me just say, look, when we're up here on plain error, and one of the points I often make is Orlano has 4 points, and unfortunately, that last point is, I refer to it as the forgotten fourth prong of Orlano, and you still have to take a look at the sentencing proceeding as a whole in order to conclude that there's plain error, and whether it brings the judicial system into disrepute. And I'm not sure what there was about the way Judge Osteen conducted the sentencing proceeding that would ever bring the district court, the judicial system, in repute. He took into account that there was obviously that the defense put on this self-defense rationale, which is just absurd. But he took into account that there was a crime of violence in the criminal history. He imposed a within guidelines sentence. He took it conscientiously. He was never informed of the nature of the objection. And I think we have an obligation to look at the sentencing proceeding as a whole, and under the fourth prong of Orlano, ask whether it brought the judicial system into disrepute. Not only did it not bring the judicial system in repute, Judge Osteen's approach to the sentencing function brought the judicial system credit. And there's no way we can just ignore that.
I see that I'm out of time. May I answer your Honor's question and briefly conclude?
Can you answer when you reserve some time for rebuttal, haven't you?
Yes, Your Honor. I'm happy to answer the question at any time the court would allow.
Well, why don't you answer the question now, and we won't take off time from your rebuttal, because I want you to have plenty of time to make your argument.
I appreciate the court. Thank you. Your Honor, I understand the court's point about the fourth element of Orlano. But I think the fundamental analysis here is that we as a system, the judiciary, all have an obligation to ensure that the application of the guidelines are interpreted appropriately and applied consistently according to the facts.
But all I'm saying is that seems to me to collapse the fourth collapse the fourth prong of Orlano into one of the first three. And the fourth prong of Orlano is supposed to be separate, and it's supposed to protect the plain error analysis and the obligation to give district courts the obligation of attorneys to argue for their clients on specific terms, and the respect for district courts to give them notice of questions that they have about the PSR. But at the end of the day, when the sun sets, we have to utilize that fourth prong of Orlano and ask whether there was anything about this proceeding that brought the judicial system into disrepute. I read the dialogue of what Judge Osteen said and everything. It was a well-conducted sentencing proceeding, and he was free to adopt the findings of the PSR, and the defendant bears the burden of overturning those findings, which I don't think he's carried. And then you get into the fourth prong of Orlano. Is there something that is just wrong and disreputable about what went on below? And that's that is put in there for a reason. It's not just superfluous. But I want you have some time for rebuttal. And if any of my colleagues have further questions of you, stay there and we'll let my colleagues ask those questions. Judge Floyd, do you have some questions?
No, sir.
Judge Novak?
I'm all good, thank you, sir.
All right. Thank you, Ms. Reese, and you have some time for rebuttal.
Thank you, Your Honor.
Mr. Painter?
Thank you. Good morning, Your Honors. May it please the court, Arla Painter on behalf of the United States for the Middle District of North Carolina. This court should affirm the district court sentence because there was no plain error or even any error in the application of the large capacity magazine enhancement. I just want to clear up a few things that go to the plain error analysis. The defense agrees, she stated that today, that the magazines and the firearm contained a total of 32 rounds. That's mentioned on page 13 of the opening brief. And of course, we've already talked about what's noted in the PSR. I'd like to draw the court's attention to paragraph 6, where it says the magazine located in the defendant's vehicle matched the firearm located next to the vodka bottle. And of course, we've already connected one of those magazines that was in the firearm to the defendant. And so we also connect the magazine in the vehicle to that firearm. So that's important because it demonstrates that we have, at the very least, one magazine involved in this offense that was capable of accepting more than 15 rounds. And that is the definition that the commission has provided to us in determining when that large capacity enhancement should apply. And
so what the thing that gives us, I think, an entry into the commentary is simply the ambiguity that the two other circuits have found. And the ambiguity there has to do, I think, with how you interpret the whole phrase large. Is that not correct?
okay. Yes, Your Honor, but just to go back to the plain error, recall that in order to even apply that analysis at the appellate level, plain error requires either one, the explicit language of a statute or a rule resolves the question, or two, at the time of the appellate consideration, the settled law of the Supreme Court or this court established that an error has occurred. Here we don't have that. We don't have a specific statute or specific case law saying that this was plain error. And to your point, Judge Wilkinson, we know that the district court didn't even have an opportunity to review this in the first place because the defense had no objections to the PSR. Again, we also didn't have an opportunity or the need to further develop the factual record because there was no notice of any objection that this enhancement would apply. So it would be, to your point, Your Honor, unfair for this court to establish plain error on those facts in the state of the law. As you noted, the two circuits, the 9th and the 3rd, the majority in both of those circuits stated that the term large capacity magazine is ambiguous, and therefore we looked to the Kaiser factors. Both of those majorities determined those Kaiser factors were met. I do want to point out that the defense relies heavily on the concurrences in both Trumbull and McIntosh, but note that those concurrences, even though they said there's no ambiguity here, could not tell us definitively what the number should be. Judge Bay and Trumbull suggested that if we're going to rely on what we know Congress's intent to be, it should be more than 10 rounds. So even assuming that, this qualifies here. Now the concurrence in McIntosh relied heavily on the capable of accepting language from the guideline itself. And he said we do not even need to decide what the capable capacity of the magazine in question was here because we know that firearm, that Ruger AR-556, could hold a magazine of up to 50 or 100 rounds. So I think the concurrences in those decisions are telling in that they can't give us an unambiguous statement, but they can tell us, even referring back to the language of the guidelines, the definition provided would still apply for a large capacity magazine. As to the reasonableness prong, we know that Congress itself told us in the assault weapons ban that more than 10 essentially means large capacity. As your honors have noted, most of the states that had a reason to define what large capacity meant went with that same standard, more than 10. We know 3 additional circuits have used the definition provided by the commission here, more than 15. Only 1 state has said it should be more than 17. But as we can see, the commission's approach in adopting the guideline definition, it noted inconsistent applications and what's qualified as a large capacity magazine.
This is, the point is, this figure 15 is a very generous one to defendants, because there are a great many states, a good many states that would say, no, you can't have more than 10. So the standard here is not draconian or harsh or anything else. It's very generous as far as the defense is concerned. Isn't that correct?
You're correct, Your Honor. The definition only further narrows when the large capacity magazine would apply. If this court were to adopt the stance taken by the concurrence in the Trumbull case, it would essentially apply that enhancement to any time there is a firearm capable of accepting a magazine that can hold more than 10 rounds. So the definition actually functions to cabin the application of the enhancement, and it is within the zone of ambiguity, as we know based on the various magazine sizes that are readily used today. So the first factor under Kaiser is, do we have a genuinely ambiguous term here? And large capacity magazine is genuinely ambiguous. The next goes to the reasonableness or the zone of ambiguity. Here, essentially, the courts are telling us to ask, is this agency responsible for helping define something in this area of the law? Here we have the Sentencing Commission that was specifically tasked by Congress to come up with some objective characters to help district courts find a guideline range that reflected the aggravating and mitigating circumstances of the offense. That's exactly what the commission has done here. The commission routinely has to give us numeric values. We know that because there's enhancements for when someone possesses anywhere from 3 to 7 firearms, or we have drug weight calculations and mandatory minimums. We have loss amounts and the financial crimes avenue. So we know that this is something the commission is capable of doing and something it's been instructed to do. So this falls within the reasonableness and the zone of ambiguity. We've also talked about the character and context, revealing the interpretation is entitled to controlling weight. Again, we know that to be true because this is exactly what the commission is supposed to be doing.
Ms. Painter, do you often, when you get these kind of cases, do you put the magazine in evidence in a plea or a trial?
Well, Your Honor, we would if there was an objection or if there was some way to interpret the facts such that.
I mean, in the proof. I mean, excuse me. I mean, in the proof of your case, would you put the magazine in and say this is a high capacity magazine?
If it were contested, Your Honor, but here the facts that were not contested made it clear that that enhancement should apply. Had this been raised at the lower court level, that's certainly something we could have explored. We could have had the agent testify as to the capacity of the magazines. As you seem to note, we don't know the actual capacity of these magazines. It could have been 17, it could have been 30, but we just simply didn't have the opportunity or the reason to develop that record. But on the undisputed facts, we know that this is a large capacity magazine under the definition.
So at the plea stage, not the sentencing stage, what did the statement of facts say as to the basis of the plea about the magazine?
You're correct, Your Honor, and I noted that as well.
What did it say?
31 rounds for the 2 magazines, Your Honor.
And is there anything in that statement of facts that indicates that this is a high capacity magazine?
Well, Your Honor, for the factual basis, we're establishing the elements for the offense. Here, that is the felon.
I understand that, and that's what he's pleading guilty to. That is what upon which he's going to get sentenced, isn't it?
It is, Your Honor, but again, we need to lay forth the foundation for the elements of the offense here. That's knowing possession of a firearm by a felon. Of course, when we get to the PSR stage, that's when he would have an opportunity to object to facts which would form the basis for the enhancement. And of course, that did not happen here.
And did the PSR do it, other than do a bullet count, did it say that it was a high-capacity magazine?
It applied the enhancement for a large
Did it
capacity.
say, did it say that it was a high-capacity magazine?
Your Honor, in the guidelines calculations, I'm looking at paragraph 14. It said, since the offense involved a semi-automatic firearm capable of accepting a large capacity magazine, a base offense level of 22 applies. So yes.
Right. And there was no objection to the PSR?
That's correct, Your Honor. And again, we would submit that that's why this court should decide this on a plain error basis. It doesn't need to get into the merits and discuss those Kaiser factors because it simply wasn't raised below.
Well, the PSR made an unobjected to finding, did it not? The enhancement applied.
That's correct, Your Honor, and there were no objections.
You know, you have a finding. You have a finding that's on point. You have a finding that this is a large capacity magazine. You have a finding that this particular enhancement applies. There is no objection to the finding. The district court adopts the PSR. This is really routine stuff. It's very straightforward. And also, when you take a step back and look at how this sentencing proceeding went forward, it is a well-done sentencing. The district court was simply not sloppy about it. The district court applied a within-guideline sentence. The district court went over the self-defense proposal and said no driving around at 2 o'clock when you're not sober is the self-defense position is just not at all credible. The district court says, look, you've got some crimes of violence in your sentence, in your background. That's what the district court is supposed to do. And the district court did it. And so the question again, under the plain error doctrine, you go through these particular steps, which we have, and you go through the finding that the PSR made, and that was unobjected to. And then you look at the sentence, whether you look at the particulars or whether you look at the sentencing proceeding as a whole. The district court did this right, and I wish that every sentencing proceeding exhibited the kind of care and meticulousness that characterized this one.
I agree, Your Honor. You touched on something I wanted to wrap up with. The defense claims that the court did not consider his argument of possessing the firearm in self-defense. That's simply not true. A quote from the sentencing transcript from the judge says, quote, to pick up a gun with an extended magazine and then have it in the car when you're driving drunk and tell me you have it for protection because of this work incident, that's not a very compelling story. So the court did consider the defense's arguments and considered those in weighing both the guideline range and the 3553A factors, and it came up with a guideline sentence right around the middle of the guideline, 66 months for a 57 to 71 guideline range. That's presumptively reasonable, and the record here only further supports the district court's approach and the district court's decision. As this court knows, we rely and we defer to the district courts for their fact-finding and for their analysis at the trial court sentencing level. Accordingly, we ask that you affirm. If there are no additional questions, I'm comfortable resting on our brief.
Judge Floyd, do you have any additional questions?
No, sir.
Judge Novak, do you have any additional questions?
None for me, thank you.
All right. Ms. Reese, you have some rebuttal time. I'm happy to hear from you.
Thank you, Your Honor. I have 3 points to make on rebuttal. First, we concluded my argument with a discussion about the fourth point of the fourth factor of the Alano analysis. That factor goes to the fairness and the integrity of the judiciary and judicial proceedings. Here, that standard is met because the government did not meet their burden. They could have read the PSR to read that it did not rise to that level of explaining sufficiently whether or not there was an actual large capacity magazine here and whether or not this gun could accept it.
Why is that the government's burden? Isn't it your burden if you have an objection to the PSR? If you had an objection to this finding that the PSR made about the applicability of the enhancement?
Your Honor,
That the government did not do this, the government did not do that, but your statement shifted the burden of proof.
Your Honor, it is the government's burden of proof by preponderance of the evidence to meet that burden for every enhancement application at sentencing. The government did not meet that burden here. They could have easily identified that in that factual basis it said 31, in this PSR it said 32. There is no explicit finding in that PSR that this firearm was capable of accepting a large capacity magazine. The government very easily could have made sure that that language was modified in order to clearly support this.
What obligation does this place on defense counsel? Or does defense counsel just to sit there and wait for the government to unearth all the errors that may be in the PSR? I mean, where does this leave the adversary process?
Well, Your Honor, it is always the government's burden. So if we're going to let the government slide by on language that is vague and not clear, then that will always allow the government to not rise to the level of their obligation to uphold their standard and their burden in these cases. It is the government's burden. It is not the defendant's burden to disprove. It is the government's burden to prove. And it is their obligation to determine when that evidence rises to the level and when it does not.
It's the government's burden if there's an error and it's a question of the harmlessness of it. That's clearly the government's burden to prove harmlessness. But where we're dealing with plain error, that's your burden. You have to show that you have to they have the burden of showing that the PSR was in some ways incorrect. And I haven't, I've been listening carefully, but I don't think that they carry that burden.
Your Honor, respectfully, we have carried that burden because when the court reads this PSR, Your Honor, I see I am out of time. May I briefly continue answering the court's question and conclude?
All right, you go ahead, but I don't want to make it, if you could make it brief, I would be most appreciative.
Yes, Your Honor, I appreciate the court. Your Honor, simply put here, there is just no evidence that this firearm could accept an extended magazine. If we go with the court's analysis that there was 15 inside the magazine, that the gun had 1 in the chamber, that is not an extended magazine because it's not more than 15. Then we're at stage where we're analyzing the magazine in the car. That takes us to prong B of the commentary, and it's our position that that commentary language expands the scope of the guideline, and that's impermissible.
All right,
I thank the court for its time this morning.
we thank you. And Judge Floyd, do you have any further questions?
Yep, yes.
Judge Novak?
All good, thank you, sir.
All right. Ms. Reese, I see that you're court appointed, and I want to express the sincere appreciation for the vigor and the conscientious manner in which you've argued your case. And we rely on court-appointed counsel to do a really good job, and you've done that, and we thank you.
Thank you, Your Honor.
All right, we will move right into our second case. All right, I think we're ready to go, Mr. Byrne.
Morning, Your Honors. May it please the court. My name is Jonathan Byrne. I'm appearing this morning on behalf of Tony Dougherty, the petitioner below. The Old English common law expected jurors to be familiar with the parties that were appearing before them and to bring to bear their knowledge of those parties in resolving the dispute. But the founders went a different way and enshrined in the Sixth Amendment a right to an impartial jury trial for criminal defendants. As Chief Justice Marshall explained in discussing Aaron Burr's trial, the great value of trial by jury certainly consists in fairness and impartiality, and those who most prize it do so, quote, because it furnishes a tribunal which may be expected to be uninfluenced by an undue bias of the mind. Mr. Dougherty was denied his right to an impartial tribunal because a juror lied to his fellow jurors about knowing Mr. Dougherty and his family and expressed a fear, which he said his fellow jurors should share, about what might happen if Mr. Dougherty were acquitted. This court should reverse the district court's...
The fear that if he were acquitted, that Mr. Dougherty would be free to roam and inflict harm or inflict injury upon the individual members of the jury?
Well, we don't know, and that's one of the things that is, I think, particularly insidious about Juror McBride's statements in this case, is that it essentially leaves open to the imagination what the negative consequences might be, which would allow other jurors to maybe go to the worst possible scenarios in their own minds, whether that is something that would happen to them or to their families, or something like that. We just don't know.
Well, one of the things we do know is that this comes to us on a 2254, and so EDPA applies, and this court, we have gotten into an awful lot of trouble in declining to apply EDPA, and as the Supreme Court thinks it's written, and we've been the subject of summary reversals, and it seems to me that we ought to take some hints from the Supreme Court, and we have to establish whether West Virginia state courts unreasonably applied clearly established federal law. You admit that's a high burden, don't you, Mr. Byrne?
Absolutely, Your Honor, yes. But I think the lessons from the Supreme Court cases that you are talking about cannot be that a petitioner can never prevail in a 2254 proceeding. And I think in this situation, the high bars are met because there is a application of federal law here to facts that is, it's an unreasonable determination of the facts because the lower courts have insisted on treating Mr. McBride's statements as two sort of hermetically sealed things. Mr. McBride said, I know Mr. Dougherty and his family, and he said, I am afraid of what might happen if we acquit him.
What's wrong with the state courts not going into a jury verdict and trying to protect the privacy and sanctity of the jury room? Seems to me that we want people to serve on a jury, and it's perfectly permissible for the state courts to say we're going to impose some limits in delving into jury deliberations because this is going to discourage people from serving, and that's something that federal law has indicated respect for. And why should we chastise the state courts for protecting that very value?
Because there's a competing value, which is enshrined in the Sixth Amendment, which is a right to an impartial jury.
Exactly, and that's why we, when you say it's a competing value, isn't it up to the state courts to resolve the balance?
With the caveat that they don't contradict established federal law.
Well, how could they contradict established federal law? Because they thought that McBride's statement was internal, and that it was simply he was relaying his own mental impression. And the state court said, well, that's internal. That strikes me as something of a judgment call, but a perfectly reasonable judgment. And I'm just not sure what clearly established federal law would say that jurors relating to what his own mental impressions are, or what he thinks that was some kind of external intrusion into the jury process. It's simply one juror saying, "This is what I think. This is what it is." What's wrong? That can't be a violation of clearly established federal law for the West Virginia courts to say that that's relaying a mental impression of a juror or somehow external. It's perfectly legitimate to call that internal, isn't it?
Your Honor, that's not all Juror McBride said. If all he had said was, yeah, hey, based on what we've seen in this case, I'm really afraid of what might happen if we acquit this guy, that's one thing. But what he also said, and it's important to commend, this is false. He falsely told his fellow jurors, I know this man, I know his family. That implies he has outside knowledge, information beyond what was presented in court at trial that informs this fear of what might happen if Mr. Dougherty was acquitted. And I think it's important.
Let me ask it this way. Did you look at the voir dire of the jury to start with as to whether or not there were any questions about did he know anybody or know anything about the facts of the case? And I mean, I don't know whether that's going to translate to any external thing, but did he do anything like that?
There was only an indication in voir dire that Juror McBride knew one of the potential witnesses, but it was not a witness who wound up testifying. There was no indication. He did not make any indication that he might have known anybody else that was involved.
So my question is to you is, how did he lie to the court in the voir dire? Did he lie to the court in the voir dire?
I don't think he did in voir dire. He lied to his fellow jurors. When they had the post-trial hearing on the motion for a new trial, he testified that he did not know Mr. Dougherty or his family. And Mr. Dougherty testified he did not know Juror McBride. But we have multiple jurors and other jurors, and their statements really have never been found to be false, who said that Mr. Juror McBride did say, I know Mr. Dougherty. And so his own testimony undermines that and really raises the question of why he would do something like that in an attempt to influence the jury's decision. And I think it's also important in looking at this case to take in the full context of it. This was not a particularly strong case from the government's or from the state's standpoint. There were 16 charges originally. 4 of them were dismissed before trial. 8 of them resulted in acquittals. And the 4 charges on which Mr. Dougherty was convicted don't make any sense in light of the acquittals.
Counsel, doesn't the acquittals show that the jury was not influenced and they did their job? If you had this strong external influence, as you're suggesting, why didn't we have 12 guilty verdicts? Instead, you only got 4. It's my experience that jurors take their work pretty seriously, and when you have a divided vote like that, that suggests to me that they did what they were supposed to do, which is to apply the evidence to the law, and they were not swayed by anything this guy said.
I would disagree with that reading of this particular verdict, Your Honor, and here's why. As I said, there were 16 original counts, and basically there were 4 counts each for 4 particular instances. And the 12 counts that went to trial, there were a group of sexual assault charges, a group of sexual abuse charges, and then the sexual assault by a guardian. Mr. Daugherty was convicted of sexual assault by a guardian, but he was acquitted of sexual assault. So the jury's verdict does not make any sense. Now, that in and of itself is not a basis to vacate it, but
Aren't we told by the Powell case that we're not to sort of, deal with, look at a jury verdict and deal with, well, this count is inconsistent with this count, that we're not to mix and match counts against one another, that the way we're to look at a jury verdict is to take each count and ask whether substantial evidence supports it, rather than saying, well, count 12 is inconsistent with the verdict on count 6, and count 7 is inconsistent with the verdict on count 8, and everything. The Supreme Court said, no, we don't look at jury verdicts that way. We look to see whether each count is supported by a substantial amount of evidence. And I think Judge Novak makes a very good point, that the fact you cite the number of acquittals as evidence of a close case, but Judge Novak makes the point that it could be equally taken as evidence of a very conscientious jury that went through it count by count and came to a conscientious conclusion. And you say it's a particularly weak case. No, I'm not sure. TJ, who was a victim here, had a good deal of, we got an extensive testimony, and it was made to number of doctors, and it was made over a period of years, and he gradually opened up about what's happened to him. There were physical findings about the doctors were dealing with physical findings that talked about venous congestion, which was suggestive of sexual abuse. Do you really think this is a close case?
I think it was, Your Honor, because the state's experts who testified about TJ's medical history and everything admitted they could not say this proves he was sexually assaulted. It is at best indications that might be consistent with sexual assault. Mr. Daugherty had an expert testified inconsistently to that. TJ admitted he made things up. He made up allegations against an entirely separate person. Mr.
Let me ask you
Daugherty,
this, Mr. Byrne. Did you, with respect to both TJ and the doctors, do you feel like you had a fair opportunity to cross-examine?
I think the trial counsel did. I think trial counsel did a fairly good job at trial. He unfortunately continued way too long with the case and created problems elsewhere. But I also think I've been doing this, certainly not as long as you have, Your Honor, but I've been doing this for a while. And this was not a case where the only defense case was cross-examination of the state's experts. There was a defense case, and it included Mr. Daugherty taking the stand, saying, I didn't do this, and then being subjected to absolutely no meaningful cross-examination. It is the wildest thing I have seen in years. And none of that, all
All
the
I wanted to
consistency.
say was that TJ and the doctors were subject to cross-examination, and that wasn't unreasonably curtailed, was it?
They were. They were subject to cross-examination. The perhaps biggest problem with the record in this case is that when it went to the West Virginia Supreme Court of Appeals, the record was not complete. And trial counsel, who then became appellate counsel, failed on that level to present the entire case to the court. So when the West Virginia State Supreme Court made its ruling on this issue, partly that anything that Juror McBride said wouldn't have been prejudicial, it was based on a record that did not include even all of the state's case, much less any of the defense case. It actually ended with TJ's testimony. And so I see my time is about ready to end here. If there are not any other questions, I will save my time for rebuttal.
Judge Floyd, do you have some questions?
No, sir.
Judge Novak, do you have any questions?
I'm fine, thank you, sir.
All right, let's hear from Ms. Wilson. We'd be happy to hear your side of it.
May it please the court. Petitioner's case hinges on meeting EDPA's formidable barrier twice. EDPA sets up a high bar, one that authorizes federal intrusion only if state courts' decisions were unreasonable. And petitioner can't clear this double hurdle. First, he can't show that the state court's decision to treat the statements separately was an unreasonable determination of the facts. And second, even if petitioner could make that showing, he still can't show that taken together, it would be unreasonable to find that the statements were internal. In 2006, the Supreme Court had never provided a formula for this determination, and it certainly had not said that a juror's implication of outside information, if there even was one here, was external. And given that backdrop, considering the statements to be internal would be entirely reasonable. The state asks that this court affirm. First, I'll begin with, it was reasonable for the state court to treat the statements disjunctively. And we have to begin with the first principle that state court findings are presumptively correct. How a statement was made and thus how to treat it, that's a factual finding. And under EDPA, if reasonable minds could disagree on the facts, the state court's findings have to stand. Here, reasonable minds could disagree. We had various testimony from various jurors on what they heard and how they heard it. And so, under the EDPA standard, treating these statements separately was entirely appropriate and reasonable. And petitioner seems to agree that this court could just stop there because he has never asserted that if the statements are treated disjunctively, that he wins. In fact, I just heard Mr. Burns say that, yes, a fear statement standing alone would be internal, and that this case would be different if these statements were treated disjunctively. So really, he has to clear EDPA 2 times. He has to show that first, these statements have to be taken together, and then he has to show that it would be unreasonable to conclude that together it would be that those should be treated as external. So I'll move to really, the key issue in the case, really, which is whether it would be unreasonable to conclude that taken together these statements were internal. And the answer is yes. Again, we start with EDPA. The analysis has to stay rooted in EDPA, and under EDPA, and this is quite an old case, we have to look back at the law as it was in 2006. And also, EDPA sets up a very, very difficult standard, and it was meant to be that way. This goes beyond clear error, and it's not enough for this court to disagree with the outcome. If reasonable jurors could disagree, habeas relief is foreclosed. And critically, the Supreme Court has actually helped us out on these questions of whether there was an unreasonable application of Supreme Court law. In Wright versus Van Patten, the Supreme Court said, where Supreme Court cases give no clear answer to the question presented, it cannot be said that state courts unreasonably applied clearly established federal law. Here, there was no clear answer on this question, so relief is unavailable. In 2006, we had 4 data points, just 4 cases, really. We had Bremer, Turner, Parker, and Tanner. And none of them really fit this situation here. So none dealt with the jurors' implication of external information that might have led other jurors to maybe fill in the blanks about maybe something this guy did in the past. Bremer held that a third party's attempt to bribe a juror was external. Turner held that sheriff's deputies that were witnesses in the trial that were also embedded with a sequestered jury, that was external. And Parker held that a bailiff's statements to jurors that the defendant was wicked and guilty was external. And Tanner just said that juror intoxication, hey, that's internal. So none of these cases really deal with statements by jurors to other jurors, statements that don't really deal with the facts of the case, statements that might mean something by implication. And so really this court need only look to, the state of affairs in 2006 and see that this really just wasn't clear. And so, which means that even if we take these statements together, it would have been completely reasonable to say that this was internal. And that simply ends the case.
Well, it would be reasonable to say that today, would it not?
Well, Your Honor, of course, we have to analyze this case under the standard in 2006, but really, I would agree with you, Judge Wilkinson, on that, because since 2006, the Supreme Court has really only decided 2 other cases that don't help us out very much, or help the court out very much and give us more information. Those cases are Warder and Pena-Rodriguez. Pena-Rodriguez says that racial bias can be external.
That's right, but this is not a question of racial bias or anything. It always has seemed to me that the line between internal and external statements has been a hazy one. And that, unless there was some sort of virulent racial prejudice involved, that what it really poses is simply a judgment call for not only state courts, but for us. And it's hard to find a state court's decision to be clearly an unreasonable application of clearly established federal law when the whole question is right on the borderline between internal and external, and when something is so clearly a judgment call on the part of a court, it's hard to say that there's a clearly established federal law that's been violated. And do you think this was Mr. Burns says, I'm just curious if this was a close case because of the various acquittals and the fact that the prosecution was only able to get guilty verdicts on 4 of the cases. I'm just curious because there's also a question of whether even if that was an error, whether it had an injurious effect on the jury verdict. Is this in your mind a close case?
Your Honor, this was not a close case. The state put on an extremely strong case. I think there are 4 points really to the state's case that drive this home. First, we heard from the victim. TJ gave testimony and he said, my dad anally raped me on 4 occasions. And that's compelling. Beyond just his own testimony, the evidence established that his disclosures were consistent and persistent, and his core of his disclosure never changed, and everyone agreed on that. Even the defense witnesses agreed on that. There was physical evidence that the report from Dr. Wallace after TJ was examined that was quote-unquote highly suggestive of sexual abuse. And the state's experts both said that TJ's pretty extreme trauma response is consistent with a child who had been sexually abused. And these were not very palatable things that happened to TJ. This boy was having extreme mental distress, defecating on himself, smearing feces, eating feces. He even actually attempted suicide. So, this was real trauma that had happened to this child. And the defense didn't really do a whole lot to undercut the state's case. The 2 experts that they had, Dr. Wyatt was the principal expert. Dr. Wyatt admitted that let's back up. The defense's theory was essentially to just gaslight the victim and say that he had been talked into believing that he had been sexually abused by his father because he had just simply had so much therapy. Dr. Wyatt admitted that he was speculating that this was the case because he didn't know what was said.
But to wrap it up, it was a perfectly fair trial, just in terms of the opportunities for cross-examination and the opportunity for the defense to put on its case. I mean, overall, it was a fair trial.
Absolutely. And the split verdict, to get back probably to the initial question, Your Honor, is as Judge Novak pointed out, indication that this was a thoughtful and deliberate jury that went count by count. This was not a runaway jury overrun by groupthink or, fear. A split verdict, inconsistent, if it, putting aside whether it's inconsistent or not, I mean, this shows that the jury went count by count and made an individual thoughtful determination.
Ms. Wilson, I'm going to appreciate your presentation. I'm going to ask at this point Judge Floyd and Judge Novak if they have further questions of you. Judge Floyd?
No, sir, I don't.
Judge Novak?
All good, thank you, sir.
All right, well, we thank you very much, Ms. Wilson. We appreciate your presentation a great deal. And Mr. Byrne, you have some rebuttal times. Please proceed.
Your Honor, thank you. I agree ultimately that the question is whether these statements Juror McBride made were external or not. Just the question of whether it comes from inside the jury room or not is not the deciding factor. And it's hard to understand how someone saying in the middle of jury deliberations, I have information that wasn't presented at trial, and we should not acquit this guy because of it, can be internal. That is just a different beast from someone saying, gee, remember the victim testified? Wow, we can't let this guy go. It's just not the same thing. And so I would say that. And also, getting back to the jury inconsistency, that has never been raised as an individual issue, and I'm not here arguing that because he was acquitted on 8 counts that this court should nullify the other 4. But if that's what the state thinks a strong case looks like, I'd hate to see a weak one.
No, that's not I think the point is it shows the thoughtfulness of the jurors. If they just wanted to get this over with and convict him because of the taint from that juror, they would have just done a runaway jury, as Ms. Wilson suggested, gone in, found him guilty, got it done. But you had really long and late deliberations in this case, in addition to the split verdict, which again points to a conscientious jury doing what their sworn duty is and taking it seriously, and somebody that's not under the influence of an external, as you would describe it, impact.
It was during that long night of deliberation that Juror McBride made these statements. And it's probably a viewpoint informed by my years as a public defender, but I see all the acquittals lined up against those 4 inconsistent convictions and say, well, maybe that is the result of them. Because one juror who was allowed to testify to it, the others weren't, but one juror said, yeah, what Juror McBride said impacted me. The final thing, what would leave the court with, is this question of reading these 2 statements together. The analogy that kind of came into my head while I was preparing for oral argument is the way it works with opinion in defamation law. If I write a column or a Substack post or something that says Governor Smith is a crook, and I lay out a bunch of reasons that are all in the public record, that's an opinion. That's my opinion of Governor Smith. If I say, I grew up with Governor Smith, I went to school with Governor Smith, I've done business with Governor Smith is a crook, that implies I know something beyond what the public does. That is a statement of fact. It's not just a statement of opinion. And I think you have to take these 2 statements and read them together for the court really to appreciate their impact. But I've made that point, and unless there are any further questions, I'm willing to rest on my briefs.
Judge Floyd?
Yes, sir.
Judge Novak?
No, I'm fine. Thank you. Thank you, counsel.
All right. Mr. Byrne, you always enjoy having you before us, and you've done a fine job, and we really appreciate the conscientious manner in which you've presented your case. And Ms. Wilson, we want to thank you as well. If everybody was here in person, we'd come down and shake your hands, but the fact that we're operating remotely doesn't diminish our appreciation for each of your presentations in the slightest. So you take care, and this court will take a brief recess.
This
Your Honor.
honorable court will take a brief recess.
Pleased to hear from you.
Thank you. May it please the Chief Justice, this Court of Appeals. My name is Cameron Blair. I'm with the law firm Wolf, Williams, and Austin, and our office represents the petitioner in this case, Mrs. Anita Baldwin, on behalf of Mr. Eddie Baldwin, the deceased coal miner in this federal black lung claim. If it would please the court, I would like to preserve 7 minutes of time for rebuttal. Your Honor, claimant respectfully requests that this tribunal vacate the denial of benefits below. The issue on appeal relates to calculation of employment history and specifically how to calculate what constitutes 1 year of employment under the Act. In the ALJ's decision, Judge Calianos calculated the employment history in a manner inconsistent with the plain language of the regulations. Specifically, I would point to 725-101A32 subsection 1. That code section specifically states that if the evidence establishes that a miner worked in or around coal mines for at least 125 days during a calendar year, then the coal miner has established 1 year of employment for all purposes of the Act. Had the ALJ...
No dispute that the critical numerical number is 125 working days, isn't it? Isn't that correct?
That is correct, Your Honor.
And that's a regulatory definition, or was that a statutory origin, or is it purely regulatory?
It is regulatory, Your Honor. It's like I said, it's at 20 CFR 725-101A32 subsection 1.
Okay. Thank you.
Had the ALJ used this criteria to calculate the length of coal mine employment, Mr. Baldwin would have been credited with 15.46 years of employment rather than the 14.14 found by the administrative law judge. At first glance, this difference may seem trivial or minor, but in the context of a federal black lung claim, this is incredibly significant.
So if we were using your, the way you would want to calculate it, you would get 5 years from 1977 to 1981. Is that correct? You would get 5 years.
Yes.
And then you would get another 6 years from 1986 to 1991. Is that correct?
That is correct.
So you have 11 there, and your argument is that 1970, all of these other years, Mr. Baldwin worked in the mines from 132 days up to 260 days, or he had the working days, and that would be 1976 and 1982, 1983 and 1984 and 1985. And you're seeking credit for those years, am I correct?
That is correct, Your Honor. In the judge's decision, the ALJ ascertained the dates of employment as the regulation requires. However, he did not take the next step of the inquiry to calculate the working days and to compare those to the...
If we did it the way you prefer, we would come up with a figure of 16 days, 16 years, is that correct?
It would be just under 16. It'd be around 15 and a half years.
Why would it be 15 and a half as opposed to 16? Because the fewest number of days was 1983, which was 132 days. But because that exceeded 125, you would be seeking a full year's credit, is that correct?
Yes, Your Honor. Yes, that is correct.
So if we have figures of 236, 273, 132, 245, 260, and we gave you credit for that, and that in addition to the 11 full years that no one apparently disputes, That would give you 16, wouldn't it?
Yeah, that is correct, Your Honor. That would be if you're giving a full year for 1976. In the decision below, employer and the ALJ relied on just on the dates of employment because they were ascertainable. But that is not the end of the inquiry. Subsection 3 of 725 101A32 specifically notes that if the employment in a given calendar year lasted less than that calendar year, then the judge may divide the minor's yearly income by the daily earnings reported by the Bureau of Labor Statistics, and that is known as Exhibit 610, is in the record at Joint Appendix 549.
But we don't have to do that here, isn't it right? We know when he worked. The issue is how the regulation reads. Under the old regulation, you would be out of luck because it talks about 1 year regular employment. It seems to me, though, that the focus under the new regulation is the 125 days. And it's as long as a minor is spending at least 125 days ingesting coal dust during a 1 year period, they are qualifying for the year of employment. It would seem to me that your argument is best suited to focus on that we should apply Shepard. And if you apply Shepard, you have a winner. And it seems to me that the change from the old regulation to the new regulation would give you that win. Am I not right about that?
Your Honor, you're absolutely right. And I think that's
Why don't you
driven.
make that argument? Because that seems to me to be a winner.
And that's driven home by the fact that the previous version of that regulation, which was before the amendments at 718.301, that regulation does not include the prefatory language, the 125 days established as a year for all purposes under the Act. I think
Essentially, the new regulation flipped the old regulation. The old regulation was more focused on the period of employment. The new regulation focuses on the period of ingesting the coal dust of being at least 125 days, but they have to put that 125 days within a certain time frame. That's 1 year. And that switch, I think, inures to your benefit, and it also makes common sense because this is a remedial statute that is designed to help good coal miners who are working so hard in very difficult circumstances. Here, it seems to me this guy most of the time did almost twice of the 125 days. All except for that 1 year, he's in the 200s. Am I not right about that?
that is correct, Your Honor. He had partial layoffs. There was 1 year, I believe, 1983. The earnings were below that threshold. Otherwise, they were above the 125 days. And as you said, in most of those years, he was, over 200 days.
Well, the lowest is still over. The lowest is 1983. It's 132. That's still over than 125, right? But most of the time, the other ones are 236, 273, 245, and 260. Essentially twice the time period that folks know that if you're exposed to coal dust during this time period, the likelihood of you end up getting black lung is pretty high.
Yes, Your Honor, absolutely. And I think
why don't we
here
just focus on the one point about, because we know when he worked. So isn't the rest of that argument kind of worthless? Why don't we just focus on, we know he worked during these days, and isn't the issue whether we should apply Shepard?
Yes, and my position, the claimant's position is that Shepard should apply in this case, given that there's no precedent in the Fourth Circuit addressing this issue, and the Shepard Court's interpretation of the regulation is most consistent with the plain language of the Act.
I think that Judge Novak makes a really excellent point, and I had some of the same questions that he did. You have a dissent in the BRB, and then you have the Shepard case. Let's say with 132 days, I think I came out with 16 years. But let's say with respect to the 132 days, a lot of those were Sunday. Maybe he was not around the coal mine during the Sunday. How should those Sundays be treated in your judgment?
Your Honor, that's such a fact-specific inquiry. I think those Sundays, I think you can address that by comparing the earnings to the 125-day figure at 610. And if that comes out to a figure below 125, you can award the fractional portion of that year as contemplated by
What
subsection.
I'm wondering about is do these days that you're totaling up, are those days where he was in or around the mine, or do those days include holidays and Sundays and the rest? What is incorporated in those days?
Well, Your Honor, the days would be the days spent working in and around coal mining. And per the hearing transcript, Mr. Baldwin typically worked 5 or 6 days per week. So even if you subtract the Sundays and Saturdays he didn't work, he would still be over that 125-day threshold. And I think the best way to address that, instead of trying to figure out exactly which day he was at the mine and which day he was not, if you can just compare the average daily earnings with what was actually earned, and then you get to the fractional portion of the year that will be contemplated under 725-101.
I mean, one thing I'm looking for here is some sort of simplicity in application, because it's trying to compute all these fractional years and everything seems to me to be that's not a simple kind of way. But I'm wondering, is it possible that something can count as a day when he was clearly employed by a particular mine, even if he wasn't, there for the full 8 hours? Can something still count as a day as long as he was employed by the particular company? Because I'm looking for something that has an advantage and ease of application. The other days don't seem to me to be particularly close. But is it possible to count that as a working day where he was simply employed or in the employ of a particular coal mining company?
Well, Your Honor, the act requires to be in and around a coal mine facility during that period of employment. During the period of employment, I would submit that any dates encompassed in that would count as a day of employment.
Well, counsel, maybe if I could just follow on to Judge Wilkinson, isn't the better route here to allow the ALJ to figure that out in the record, but applying the right legal standard, which would be the Shepard standard? Like if you read the regulation in the manner that I'm suggesting, which I think is consistent with Shepard, the ALJ then could do the fact finding that I think my friend Judge Wilkinson is suggesting, to figure out what are full days and which ones are not. But you got to start off with the right standard, and I think it seems to me that the ALJ did it wrong. They used the old regulation and the old law from the two-step process as opposed to the new regulation. And I think if they did that the right way, then they could do all the wise things that my friend Judge Wilkinson is suggesting and make a record, which is what ALJs do. Do you think that might be the way to go here?
I noticed that my time is up. I'd request permission to respond.
I'm interested in hearing the answer to Judge Novak's question.
I think that's absolutely right, and I think that's what should have happened here. The regulations do require the judge to ascertain the dates of employment to the extent possible. At that point, if a 365-day relationship is established, then it's presumed the claimant worked 125 days. Thereby, that leaves the calendar year. That language remains relevant. However, if we have a partial year, such as we have Mr. Baldwin for those 5 years, then the ALJ must utilize a 125-day rule as outlined under Shepard. And again, in Mr. Baldwin's case, if the plain language of the regulation is applied and it's interpreted consistent with Shepard, then Mr. Baldwin certainly is credited with more than 15 years of coal mine employment, and he should have benefited from the causation presumption at 718.305 that advises that individuals with more than 15 years of coal mine employment and confirms total disability, pulmonary respiratory disability, presumed disabled due to pneumoconiosis. With the ALJ improperly calculating the employment history, he improperly deprived Mr. Baldwin of this presumption, and the claimant submits the claim must be remanded for the ALJ to calculate the length of employment, properly utilizing the language in the regulation.
All right, we thank you very much. Let's hear from Mr. Sigmund.
Yes, Your Honor, may it please the court, my name is John Sigmund. I represent Island Creek Coal Company in this appeal. The court is asking the right questions, and there needs to be a little bit of context provided here. It's certainly true that we need to get to what the actual language of the regulation states here. When doing so, the court is always allowed to consider the legislative history. And if we do so in this case, this is a regulation that was promulgated through formal notice and comment rulemaking. The director published 2 sets of comments, and then its final findings with the preamble to the final rule. And the director specifically...
But counsel, don't we have a very clear regulation, it seems to me. It seems that it says if you get 125 days in the coal mine during a 1-year time frame, you qualify for a full year employment. And to me, it's an obvious flip from what the old regulation was. Why do we have to go to any other history when the plain language of the regulation, to me, is strikingly clear, and it makes sense. It makes sense because what's important for black lung is how long you ingest it. And what the regulation is envisioning is that somebody spends over 125 days working in a coal mine during a 1-year time frame. Likely, that's going to lead to black lung at some point. Doesn't that make common sense to you? Particularly, this is a remedial statute.
Well, Your Honor, with regard to remedial statutes, the Supreme Court said that even where a statute is remedial, we have to go by the plain text and structure of the regulation or the statute.
Well, that's what I wanted to do. That's what I'm telling you.
Okay. In this case, Your Honor, the referring regulations, so we're talking about 725-494 or 725-305, discuss years of employment. And then when you jump to 725A32, you get to the opening paragraph that provides the general rule. And that is a year of employment is a 365-day period or 366 days in a leap year, or partial periods of a year during which he has at least 125 days of coal mine employment. After that, in the opening paragraph, it sets forth what a working day is and what an approved absence is. Judge Wilkinson had asked about that earlier. The significance of the approved absences is that the director chose to codify the rulings of the 10th Circuit, which was that when considering the prior regulations, they determined that when considering whether or not a claimant had proven a calendar year of employment,
I have a hard time figuring out exactly what the BRB and was doing here. And the one thing that I'm looking for is some consistency and ease of application. And the easiest way that I can see to get at it is to say, if you work 125 days in or around the coal mine, you get a full year's credit. And that would adopt the Sixth Circuit opinion and the BRB's dissent. And that seems to me straightforward. and to follow exactly what the regulation says about year means a period of 1 calendar days during which the miner worked in or around a coal mine for 125 working days. And either he did or either he didn't. But just all the fact finder needs to do is look at the record and say, were you around or in a coal mine for 120 days or 125 days? And if you were, then you get the credit. And wouldn't there be an advantage not only in the simplicity of the application, but also in following the text of the rule, and also in aligning ourselves with the Sixth Circuit? I suppose this circuit and the Sixth Circuit get as many of these black lung cases as any other circuits in the country. And if we are aligned, we avoid the awkward posture of a circuit conflict. So what I'm asking you is that doesn't the combination of an ease of application plus the advantages of aligning with another circuit, plus the wording of the regulation, don't they all suggest what Judge Novak is saying to you?
Well, not in this case, Your Honor, and particularly under the Loper-Bright analysis, where it said that uniformity, for uniformity's sake, is not, they wouldn't assume that Congress would want that over the correct application or interpretation of the regulation. But if I'm...
How do you see, this sentence seems to me to read so straightforward. Year means a period of 1 calendar days, or partial periods totaling 1 year during which the miner worked in or around a coal mine for at least 125 working days. Well, either he did or he didn't, and that's a classic fact-finding situation which lines up with the language of the regulation. And the fact that it aligns with the Sixth Circuit is a bonus, but it's a plus that the textual reading plus the ease of application seems to also go in the Sixth Circuit direction. What's wrong with what?
It would, a straight 125-day rule would certainly make things easier, but it would also nullify the vast majority of this regulation, because it is always going to be easier to prove that 125 days based on the tools that are available. But that's not the intent that was set forth by the director when promulgating the regulation. And when you read all of the regulations together, the relevant regulations, and give effect and meaning to all of the terms in there, it requires a 1-year employment relationship.
If must pardon my saying so, but in trying to thread my way through this regulation, it's a bit of a morass, and it's quite complicated, and you have statements going this way and you have statements going that way and all the rest, and you're just having people trying to figure out something that shouldn't be all that hard to figure out. It strikes me, reading the whole thing, and it's quite lengthy, but it strikes me that this may be something that's too complicated by half. And that's another difficulty I'm having with it. But I think Mr. Doyle has, if any of my colleagues has questions for you, that's fine. But Mr. Doyle, I think, has some time to make his points, okay?
Thank you, Your Honor.
All right, Judge Novak, Judge Floyd, do you have some questions of Mr. Sigmund?
Oh, sir.
I think I've exhausted everybody's patience. Go ahead.
All right, Mr. Doyle, let's hear from you.
Thank you, Your Honors, and may it please the Court. Michael Doyle on behalf of the Director, OWCP. I did want to inform the Court that you were speaking of possible circuit split, Judge Wilkinson. As it happens, the 11th Circuit Court of Appeals will be hearing oral argument tomorrow in a case that raises this very question. The case is called Hayes versus Director. So we'll have to see what the 11th Circuit says, and if they decide their case before this court does, one of the parties here will certainly bring that to your attention.
Well, thank you for notifying us of that. We appreciate it.
Yes. I will say, I agree with everything Mr. Sigmund said. I think the clear intent of the regulation was to maintain and to carry forward the two-step inquiry that this court found in Armco. And I think in our discussion that I've heard so far, there's been some discussion of Shepard, but not of Armco. And I think it's important to understand that, especially Judge Wilkinson, if it is the morass that you've suggested, then I think looking to the preamble is appropriate. And the preamble couldn't be more clear that what the director intended was, in order to have a year of coal mine employment, the regulation contemplates an employment relationship totaling 365 days, within which 125 days were spent working and being exposed to coal mine dust. And so, contrary to Judge Novak, you're suggesting that we were trying to flip. We were trying to carry forward what had already existed, and we were trying to, you see in the preamble, the director specifically stated that he disagreed with the decisions from the 7th and 8th Circuits in the Yauk case and in the Landis case, which adopted the 125-day rule. They specifically said that that's not what we're going for. We do want the two-step inquiry to carry forward. There has to be a year of coal mine employment of being employed with this operator, within which 125 days that was spent mining coal.
Well, Mr. Doyle, let me ask you this. Not to suggest that a coal mining company would do this, but if they wanted to avoid having to pay out the black lung benefits, which I think would probably be pretty expensive, every year they could have a coal miner work 300 days and then take 1 week and say, we're going to lay you off over Christmas. And every year they lay them off, and under your reading, even if the miner worked 300 days in the mines ingesting coal dust, they wouldn't get a year qualified just because the mine elected to do that. That seems to me not to be appropriate. It seems to me that what instead your department did was to shift the focus to the 125 days. But am I not right? They could not, and I'm not suggesting a coal mine would do that, but there's been some history in our country about coal mines. Not coal mine operation not been so great. A coal mine could do that every year. Say, you know what, I'm going to lay you off over Christmas. We'll give you a huge holiday bonus. In fact, the bonus is going to be 2 times what your pay would be. But I'm going to lay you off for that week just so you don't get to claim that 1 year. Isn't that the way, under your reading, couldn't that happen?
I guess it could, Your Honor. I will say that if there's gamesmanship going on of what you're suggesting, there is within the regulations, the finder of fact could say that that layoff really isn't a layoff. It's not a break in the employment relationship. It's really just a ruse to try to get around it. I'll also say that most of these coal mine operators are paying for this through insurance. So the incentive on the behalf of the coal mine operator isn't really there. And they do lose
their insurance rates go up. I suspect the more people that are filing claims, the higher the rates, right?
That would suggest that the rates are sensitive to what you're talking about, that there really would be and I've never heard of such a thing actually happening.
Let me just ask you a simple question. How can somebody who's been employed for 260 days or 245 days or 273 days, how could that person not get credit for a year in in the mines. I mean, how does somebody work a period of employment of 273 days or 260 days or 273 days, 245 days? How do they not get credit for a full year? That's way in excess of 125.
Your Honor, I think you're confusing the dates of employment. What we have here, the record doesn't tell us how many working days Mr. Baldwin worked in the mines. All it tells us is the length of employment. That's all we have here. And he did get credit for partial years for those. So in other words, in 1982, when there was 273 days of employment, the employment relationship was 273 days. He got credit for
But if he was
3/4 of a year.
okay, I got that if it's 273 days, and it seems unlikely, to say the least, that 125 of those days wouldn't have been around the coal mine. I mean, is that, how could it be that somebody is employed for 260 or 273 days and didn't work 125 days around the coal mine? That would, they didn't employ him just to be sitting around. The whole business model of the coal mine required that someone who was employed work in the business of the company, which was mining coal. So how does it happen that somebody doesn't get a full year's credit for 273 or 260 days of employment?
I think, it very well may be that he had 125 working days. All I'm saying is it's not in the record. But to answer your question, the regulation is clear. Congress said in the statute there has to be 15 years of employment working underground, right? So the Department of Labor did a notice and comment rulemaking in order to try to figure out what a year would mean in that context, and also in the context of responsible operator having to employ a miner for at least 1 year. They came up with this.
Mr. Doyle, I am not speaking for my two colleagues, but I hear them say that they would like to adopt the Sixth Circuit rule, and as would I. Are you opposed to that?
Yes, Your Honor.
Are you opposed to it?
I'm opposed to this court adopting the Sixth Circuit rule, yes.
Why?
Because it's inconsistent with the language and the intent of the regulation. The Sixth Circuit they made a hash of the regulation. They took out words that are in the regulation, and they placed words in the regulation that aren't there. It's a misreading.
Well, let me ask it this way. If we look at AMCO, whatever our precedent was, that's the full paragraph, and the way I read it, you got 3 subsections that are added to that full paragraph, and those 3 subsections tell you how to get to 1 year, and the baseline is 125 days. Is that not correct?
It's not correct. What it's doing is telling you various ways to get to 125, but it's still saying in the opening paragraph and in the Part I that you need to have those 125 days within the 1 year employment relationship.
Let me back up again, and maybe you're headed in a way that I had some question. Are we talking about a calendar year, or are we talking about, let's say a miner starts in July and he works till July of the next year, and he gets that 125 days in or around the coal. Is he going to get credit for a year?
He would there. That would be a calendar year.
So I'm not following you there, if that's the case.
The problem in this case, in Mr. Baldwin's case, is he didn't meet the threshold employment relationship of a year. So for instance, in 1976, he worked from May 10th through December 31st of that year. So that's not a calendar year.
But the new regulation doesn't say the 1 year of employment. That you would win. You'd be right under the old regulation. It seems to me that there's now a new two-step process. It flips it, and the question number one simply is, did he work 125 days in and around the mines? And then if he did, the next question is, was it within a 1-year time frame? That to me ends it, and going back to my friend Judge Wilkinson's question, to make it simple, why is it we don't just remand it to the ALJ? Because we review issues of law de novo. Tell them to apply Shepherd, and then they can figure out whether or not he actually had the 125 days, but using the new two-step process instead of the old two-step and the old reg, which is what you're advocating for.
Right, it's just because the old two-step is the same as the new two-step under the regulation. I think that you're suggesting that there's a flipping going on is just something that we disagree with. It's completely, if that's what we intended.
To follow up on Judge Novak and I think Judge Floyd's question, why wasn't this regulation made a whole lot shorter and a whole lot clearer, rather than this morass, and leave some of the details up to the fact finder as to whether those 120, it's simple, whether 125 days were spent in and around the coal mines during the period of a calendar year. And, then that ends all this explanation that gets people scratching their heads and breeds litigation and everything, can be set aside in the interest of clarity and simplicity and delegated to the fact finder to answer the question of whether somebody worked at least 125 days or in and around the mines during a calendar year. And as Judge Novak points out, that goes right to the heart of what Congress was trying to accomplish, which was, let's look at the extent of this individual's exposure to coal dust. All I'm saying is that, you could wear a crown of glory if, as an agency, you made it short and simple and deferred to fact finders. And this is, you do the whole world a favor. This is an important program, and you do the whole world a favor. But I'm just, I know I'm not expecting you to agree with me or anything, but all I'm saying to you is that, whoever the wonderful draftsmen are, might include brevity and simplicity as desirables in their drafting process. I mean, the opening statement of this regulation gets you almost there. You could have saved yourself an awful lot of work. But I know you don't agree with me, and that's fine. I respect that. But I'm just, I'm just saying. Anyway.
Yes, Your Honor. If I see my time is up, if I could just briefly say one thing about that, Your Honor.
Can you be brief?
I'll be brief. I just would suggest that the Armco Court did look at this regulation and use it as a basis to clarify and to affirm its understanding of the old regulation. So in order to agree with Shepherd, you're going to have to figure out how to get around Armco, and I just don't think you can do that. And I don't think that was at all, if you read the preamble, the flipping that Judge Novak suggested was simply not the intent of the authors of this regulation. Thank you.
Well, I just have a problem that we may not be, we may be shortchanging the miners with this when we, and short-circuiting Congress's intentions when we leave it open to somebody that has worked 273 days not to get a full year's credit. I just wonder whether we're not shortchanging the minors, and that it is, it is a remedial statute. I mean, we didn't, we don't vote for or against it, but what we have is remedial. Well,
It's remedial, but it does say 15 years. It doesn't say, you could have 125 days working, and you could get that in 8.5 years, Your Honor, or less than that.
Nobody's trying to fool around with the 15 years, which is, the question is how the years are. I mean, if that's unduly stringent for a company to meet, then you go to Congress and have the interim presumption kick in after 20 years or even longer. But it seems to me that maybe the legislative route is the way to go. But anyway, Mr. Doyle, I really appreciate your assistance. And if Judge Floyd or Judge Novak has some further questions.
I don't.
All good, thank you.
All right. Okay. You've got some rebuttal time, Mr. Blair.
Thank you, Your Honor. I would like to start out by first addressing the Armco case. Again, that case dealt with the interpretation of the prior version of the regulation interpreting the length of employment. So we're comparing apples and oranges here. I don't think the court has to overturn Armco simply because that case was not addressing the current version of the regulation. The other point,
It was dicta. Armco had, that was pure dicta, that's all, right?
that is correct, Your Honor. The other point I would make is that the two-step inquiry is not maintained in the plain language of the regulation. A32 simply states that a year is a period of one calendar year when there are 125 working days. There is no mention that there has to be a continuing employment relationship. And to Mr. Doyle's point that an individual could work 8 years and get credited for 15, that's simply not correct. As the regulation specifically states under subsection 1, proof that the minor worked more than 125 working days in a calendar year does not establish more than 1 year of employment. And I don't think that we're...
Mr. Blair, isn't the way to do this as follows? If we decide whether or not we want to apply Shepard, it sounds like my colleagues and I are seeing it the same way. If that happens, it goes back to the ALJ. The ALJ then, they've already found the 11 years for your client, right? They would apply Shepard and decide whether, essentially what I'm going to call the new two-step, which is, did he work 125 days in a 1 year time frame for each of those, each time frame, right? And if he does, then if he gets to 15, there's a rebuttable presumption. Of course, your opponents then can always put on evidence to try to overcome the presumption. Now, the fact that your client's dead and I think he died of black lung is going to be a tough road for them to hoe, but at least we'd have a fact finder to be able to figure that out. Isn't that what the right answer is here?
That's absolutely the right answer, Your Honor, and that's what we would request. And I think that that's borne out by a scenario that's easily imaginable. Many of these minors live in one state and work in another state. So consider a scenario where both minors work in Pike County, or both minors live in Pike County, Kentucky. One minor works in Kentucky, one minor works in Virginia. They have layoffs similar to what Mr. Baldwin experienced. The Kentucky minor is going to get the benefit of the 15-year presumption. The West Virginia minor will not, despite the fact that they have the same exposure, and that is simply not what the regulation contemplates. I think applying Shepard here not only is, it serves a favor of consistency of application, it's most importantly, it serves the plain language of the regulation. And I agree with Your Honor. The proper course here is to vacate the denial and remand the claim to the ALJ with instructions to recalculate the partial years of employment utilizing Shepard and the plain language of the regulation.
All right. We thank you both very much, and we will, I wish we could shake your hands, but we can still express our appreciation to you. And we will now proceed into our final case. Ms. Scarberry, we'd be pleased to hear from you in this final case, okay?
Thank you, Chief Judge Wilkinson, your honors. May it please the court. My name is Denise Hall Scarberry, and I represent the petitioner Rhino Energy LLC. Petitioner requests 15 minutes and reserves 5 minutes for rebuttal. Petitioner Rhino Energy LLC respectfully asks that this court vacate and reverse the decision of the Benefits Review Board and the Administrative Law Judge. For 2 reasons. First, the board erred in finding that the Administrative Law Judge did not err when she found Rhino Energy as the appropriate responsible operator for this claim. This was for 2 reasons. Because the last employer of Mr. Rule, Wildcat Energy, was a successor operator of Rhino Energy and as a result met the requirements of a potentially liable operator. 2, because Wildcat independently employed Mr. Rule for the requisite period of 1 year, as that term is defined and delineated within the Black Lung Benefits Act, again qualifying Wildcat as a potentially liable operator.
Excuse me, you've heard discussion in the Baldwin case. Does that, if we, let's just say, assuming arguendo, that we voted to vacate and remand and to calculate in accordance with Shepard, what if, should we do the same thing? Should we, in this case, should we, if we took that view, if we were to take that view in Baldwin, should we remand this case in light of Baldwin, or does your case have an issue that is totally independent of the Baldwin, what we do in the Baldwin decision?
Yes, Your Honor. Actually, my case does have an issue that is independent of the issue in the Baldwin case. That is the successor operator issue. Here, even if you decide not to rule as Shepard has and find the 125-day rule, then there was still a subsequent employer that had 1 year of coal mine employment. That's because Wildcat was a successor operator of Rhino Energy, meaning that they took over the exact same mine site that Rhino had operated, acquiring the assets thereof, and mining at the same mine site, utilizing the same equipment, employing the same co-workers. And because of that, the time that...
But you're saying that question of a successor operator swings free and clear of the discussion on the interim presumption and the calculation thereof.
Yes, Your Honor, that's correct. It swings free and clear because the time that the miner spent employed by Rhino and the time spent employed by Wildcat is aggregated together. And when you do so, the miner clearly worked for 1 year or more. He worked from 2012 through 2014 for Rhino. And if you add in the time that he spent at Wildcat in 2015, clearly that's more than 1 calendar year and more than 125 days. So the 1 year requirement.
This kind of determination, I'm just sort of posing the question, assuming that we agree with you that this is an independent question, what kind of deference do we owe the director some, we were a little bit hard on the director in the previous case, but it's still, the question is whether the director is due some deference on a question like this, because the director decides these issues regularly and has an expertise in it, and the director has the best chance of applying uniformity here. Deferring to the director does have the advantage, it seems to me, of sparing this court from a slew of appeals. And one of the problems with these black lung cases is that they drag on and on and on, and the beneficiaries just have to wait. Sometimes it seems to be interminably before they are able to decide whether they get the benefits that are due them under the Act. So it doesn't, according to the director, some deference here due to the director's expertise and due to the director's opportunity to apply a uniform standard. And then there's the additional advantage that the litigation process or the adjudicative process, which drags on and on in these black lung cases, can be resolved at an earlier point in time, and the minors receive the benefits that they're due. So I'm just asking you, isn't there an argument at least to be made that some deference is due on the question of whether someone is or is not a potentially liable employer?
Your Honor, to answer your question, as you are aware, the Chevron case previously held that the agency who developed the regulations should have deference, but that case was recently overturned with the Loper Bright Enterprises versus Raimondo case, which says that all relevant questions of law should be decided, and it's at issue for the judicial courts to interpret the law.
Well, that's fair enough, but Chevron didn't, or the Loper Bright didn't just render the agency's view sort of irrelevant or outside the record, and it's still open to us to apply Skidmore deference and find the director's opinion persuasive. And what's unpersuasive about the director's opinion here?
Your Honor, even if we assume that the director is due deference in this case, we don't get to that issue of applying deference because we have plain text here that has plain meaning. And so we have to give meaning to the plain text. The law itself is clear. The regulation is clear. It specifically says that a year is one calendar year with 125 working days. And then there are 4 subsections of 725.101A32, which specifically delineate and offer guidance as to how to determine the 125 days or the 1 year of employment, Your Honor. So based on that, we do not get to the issue of deference because the law is clear in and of itself. So there's no need to defer to the director for deference, Your Honor. The 101A32 specifically allows subsection 3, which says that even when there is not a calendar year of coal mine employment with a particular employer, you can still establish 1 year by dividing the miner's yearly earnings by the daily average earnings, which is referred to as Exhibit 610 of the Black Lung Benefits Act Procedure Manual.
All right, is there a dispute about the 125 days and whether the miner worked 125 days during the year?
No, Your Honor. This miner worked 125 days for Wildcat Energy. He worked from January through October, which was less than 1 calendar year, but obviously just shy of 1 calendar year. And we don't have exact dates of employment. We don't know what day he specifically started and what day he specifically ended. So subsection 3 tells us that when we don't have exact dates of employment, we can use the Exhibit 610, the miner's Social Security earnings record, and divide the yearly earnings for that particular year by the daily average earnings. When we do that, in this case, the miner had earned approximately $77,000 during his employment with Wildcat Energy. For the year 2015, the daily average earnings was $244.72. And if you divide that out, that equals 318.16 days. So clearly, Mr. Rule's earnings and testimony also established more than 125 working days with Wildcat Energy. Therefore, Wildcat Energy should have been named as the responsible operator in this particular claim.
Counsel,
Well,
I'm sorry, Judge Floyd, go ahead.
All right, thank you. If we were to adopt Shepherd, would it shift the liability from Rhino Energy to the trust fund rather than Wildcat?
It would, Your Honor. Yes, Your Honor, it would shift the liability to the trust fund, and that's because the district director essentially gets one bite at the apple to name the appropriate responsible operator. Here, the district director chose to shortcut the analysis and simply rely upon the Armco case and the prior holding and not actually go through a step-by-step analysis. To arrive at a designation of a responsible operator requires reviewing 6 different regulations. So you can't just rely upon one regulation, you have to go through all 6. Ultimately, the issue here in this case is whether or not 125 days would meet the 1-year definition. And as we've established, and it's not at contest, there is 125 days, therefore liability would be shifted to the Black Lung Disability Trust Fund.
Is it accurate that the director is not permitted to correct the responsible operator designation at the hearing level?
That's correct, Your Honor. The director is not permitted to correct the designation of the responsible operator. Again, they basically get one bite at the apple.
So how does that play in this case?
So they named Rhino Energy, which is who I represent, Your Honor, when they should have named Wildcat Energy. The Social Security earnings record clearly demonstrated that the minor had subsequent employment with Wildcat Energy, and that employment lasted more than 125 days. Therefore, they should have named Wildcat as the responsible operator, Your Honor.
So if we were to agree with you, adopt the Sixth Circuit, would our instructions include such a designation that Wildcat is responsible on remand?
Yes, Your Honor. You could reverse the decision and find that there's 125 days, therefore that finding's not contested, therefore they should have been named as the responsible operator. You could also remand for further instruction to determine whether or not all conditions of a potentially liable operator have been met. The employer contends obviously that they have been. There's another issue in this case as to whether or not there's an ability to pay by the subsequent operator. However, the employer contends that that is satisfied because there's a presumption within the regulations which specifically establishes that when the district director fails to include a statement that the company is not insured or not able to pay their liability, then it is presumed that they are in fact capable of assuming liability for the claim.
Well, if I could just ask you about that, because it seems to me the difference between Baldwin and this is, the first question is, do we apply Shepherd? So if we were to apply Shepherd, that first part you would prevail on. This next question, though, is the issue of financial solvency for a Wildcat. And my reading of the ALJ's opinion was there was no mention of that. Now, there's a fight back and forth between you and the director about who has the burden, but it doesn't really matter because the ALJ didn't flesh it out. So it seemed to me that should we not go back to the ALJ and flesh out the issue about financial solvency? And then the third part of it, you mentioned briefly in your opening remarks about successor liability. I think the director's saying they admit that they erred there, was just harmless. Why don't we just send it all back to the ALJ, tell them to apply Shepherd, figure out if the minor had the 125 days, and then do their job on the second and third questions, which is Wildcat financially solvent or not? I believe one of the briefs, it might have been the director, had a footnote saying that they're now bankrupt. I don't know if that's true or not because it's not in the record. But why don't we have the ALJ flesh that out, and then they could also fix the error about successor, and then we can figure out, have an appropriate record to answer all these questions. Otherwise, why don't we let the ALJ do their job once we decide what the appropriate legal standard is? Do you agree with that?
Your Honor, we absolutely could send this case back and let the administrative law judge make further findings. However, I think based on the record that we have before us, the district director did not comply with their duty under the regulations. They are required to explain their findings in their proposed decision and order and their schedule wherein they designate a responsible operator. Here, the district director only offered up an explanation saying that the miner had worked briefly for Wildcat Energy in 2015. No other explanation was offered. There was no explanation indicating that there was no inability to pay. The employer, Rhino Energy, is just simply a coal company. They don't have the ability to know whether or not Wildcat Energy has insurance or doesn't have insurance, or whether or not they're bankrupt. That's not something that they would keep up with, Your Honor, but the district director does have that ability. And if they were determining that Wildcat was not capable of paying, then they should have explained that. They did not, they chose not to, and they transferred this case to the Office of Administrative Law Judge without any such statement indicating that they were incapable of paying. The regulations specifically tell us in 20 CFR 725.495D that when there is no such statement included in the record, then it is presumed that the miner or that the company was capable of paying benefits. As such, we can presume that Wildcat Energy was capable of paying benefits.
But don't we need a predicate finding under Shepherd with respect to Wildcat? I mean, we need to, basically, isn't the question that we need to know more? You use, your alternative to Rhino is Wildcat. Don't we need to know more about Wildcat? We have so little information about Wildcat. And don't we need to know two things? Number one, did he work for 125 days? And then number two is what the financial solvency and what financial status is. But we have those, we have two things that it might be useful to learn about Wildcat. What's wrong with finding a little bit more about Wildcat?
Judge, I see my time has ended, and I would like to respond to your question if that's okay.
Yeah, but if you can do it briefly, because we've given you some extra time already.
Yes, Your Honor, I'll be absolutely brief. To answer your question, Judge, at this point in time, it's too late to find out information about Wildcat Energy. The fact of the matter is that information should have been included. The director had the ability to include that information, and they did not, which would have led to a further investigative process by my client, Your Honor. But they did not include the information or give us the tools or explanation needed to adequately do our jobs, Your Honor.
The director decided here that it had not, I think that Wildcat hadn't employed the miner for a year. Is that still true after Baldwin?
Again, with permission to answer your question, Your Honor,
Yeah.
I'll be brief. They found that he was not employed by the employer for 1 calendar year, not 125 days. The record is clear. There absolutely was 125 days of employment based on the miner's very own testimony himself, as well as the Social Security earnings record and the exhibit.
I'm still troubled by the fact that Wildcat seems to be something of a mystery employer. I mean, you set up the case as to whether Rhino or Wildcat is the potential operator and everything, and yet there's so much about Wildcat that we really don't know, and maybe that's why, I don't know whose fault it is. Maybe Wildcat had the responsibility there, but let's hear from Mr. Austin here. And then you have some time for rebuttal, Ms. Scarberry, so we'll come back to you, okay?
Thank you, Your Honor.
No. Mr. Austin, you're on mute, and unmute yourself, and let's hear from you, sir.
Can you hear me now, Judge Wilkinson?
We can hear you fine.
All right, great. It's always an honor to be before this court. I've appeared before this court several times and before you, Judge Wilkinson. May it please the court. I have to say, however, this is my first time appearing before this court and agreeing with an employer's counsel. But I agree with Ms. Scarberry. I think this issue regarding year, as you heard from my colleague, Mr. Blair, in the last case, is a very important issue for many purposes, as this court can obviously tell from all these arguments today. Judge Wilkinson, I had a lot to say about this, but I think the court's heard quite a bit of the arguments pertaining to A32 and all the definition. But I want to ask the court to consider one thing that you just addressed with Ms. Scarberry. The director does not get multiple opportunities to name the correct RO. And the reason that that's important here is because the director relied on an incorrect interpretation of the statute regarding year to find that Rhino Energy was the RO. So I do not want this court to remand this case back to the ALJ for further findings. I want this court to reverse the issue regarding responsible operator. And there's a clear reason for that. Because if this court applies the Shepard standard like Judge Novak has been saying, which I agree wholeheartedly with Judge Novak's analysis, if you apply the proper Shepard standard in this case, it is clear from the facts that there was 125 working days with a subsequent employer. So applying that standard to the facts of this case, Rhino was improperly named from the very beginning. As you said, Judge Wilkinson, my client has waited years for finality in this case, and remanding the case back to the ALJ to make those additional findings is unnecessary. It is a second bite at the apple, which the director does not have the right to do. That evidence should have been developed at the district director level. It was not. There is no dispute at this point in time that Mr. Rule is entitled to benefits. He's proven every element of entitlement, and in fact, Rhino Energy does not contest entitlement. They only contest liability. And I assume the director does not contest entitlement, given that, it's previously made that finding. So I don't ask this court to remand, I ask this court to reverse. And I think this court should absolutely apply the Shepard standard because words do matter. If you look at A32, it says, quote, for all purposes under the act. And Judge Novak, you've outlined that, ad nauseum today. I mean, you hit the nail right on the head.
Well, I've always been ad nauseum. I mean, that's consistent with my personality. But let me ask you this. I'm concerned, though, about the direct reversal. I mean, I'm sympathetic to the fact that minors don't get these benefits sometimes till after they're dead, like in the Balt case, right?
Yes, Your Honor.
But in this case, it seems to me that there really is a three-step process. And the second is the financial solvency. And I think the director brought up the fact that needs to be addressed, that they could still have an affirmance in certain circumstances. I'm not sure I agree with that. But the record is so devoid. In fact, I don't see anything in the ALJ's finding about financial solvency. Why don't we just send it back and let them address that quickly and fix the third issue, which is the successor issue. Now, I think it was the director that said in their briefs that Wildcat is insolvent. I mean, maybe that's true. I don't know if it's true. It's not in the record. It was just a fleeting reference in a brief. But I think we need to figure that out and get it right. And I say with all due sympathy to your client, why don't we just send it back, let them just address it. If they're bankrupt, they're bankrupt. If they're not bankrupt, they're not. And we can kind of go from there.
Judge Novak, I respect that position and I understand where you're coming from with it. But I guess my question, I'm not trying to ask the court a question, but what real difference would that make in this case? Because if this court applies Shepard, the only finding would be that Rhino is improperly named from the very beginning. And either way, the case is a trust fund case because of that improper application of the regulation. So I don't disagree with what you're saying, but I want the court to consider the practical aspect of what's actually going to happen here. if the court remands this case with Shepard-like instructions, and I do see that my time is almost out, could I have just a moment, Judge Wilkinson, to
Sure.
conclude?
Sure.
If this court, which it should adopt the Sixth Circuit's Shepard standard, if this court does that, that's exactly what's going to happen. It's going to become a trust fund case. So I just encourage this court to consider that. I respect your position, Judge Novak, and I understand why you would make that. But for all practicality, it's going to end in the same result. And if I could just, I wanted to touch on this, Judge Wilkinson. I know I'm out of time. Could I make one brief point about precedent within this court?
Yeah, sure.
Judge, I was just going to say the Armco and the Daniels versus Mitchell decisions did, they came out in the years 2002 and 2007. But Judge Novak, you hit the nail on the head. That at best, that's dicta. They did not apply any kind of clear interpretation of the current regulation, because that current regulation was not in place at the time those two decisions were issued. So I know my friend on the other side, Mr. Doyle, will argue that those two cases have precedential value before this court, but I argue they do not. They do not have precedential value before this court. And the sister circuit, the Sixth Circuit, deals with a lot of federal black loan cases. They have squarely addressed this issue. We think that logic is sound. It's in line with the remedial nature of the act, and it applies to regulation. Thank you, Judge Wilkinson.
Thank you, Mr. Austin. We appreciate it. Mr. Doyle, let's hear from you.
Yes, Your Honor, thank you, and may it please the court. I do want to clear a few things up and points that I agree with opposing counsel about. Your Honor, Judge Wilkinson, as to Wildcat, I think the parties are in agreement that Mr. Rule had 125 working days with Wildcat, and also that the dates of employment were January 1st, 2015 through October 30th, 2015, which was less than a calendar year. So that's all we really need to know about Wildcat to resolve this case. I will also say that Mr. Austin's client is going to get paid one way or the other. Nobody disputes entitlement. It's only about liability. Is this going to be Rhino paying this, or is it going to be the trust fund paying it? Wildcat will not be paying it in any case, because if it's determined that Rhino was incorrectly named, then it will be the trust fund paying, not Wildcat. Now, I did want to, Judge Wilkinson brought up the notion of deference, which I don't think we talked about during Baldwin, but I did want to suggest to you that Kaiser versus Wilkie from the Supreme Court is still good law. It was not overturned by Loper Bright. And so the deference that we are claiming here is not a Skidmore lesser type of deference. It's our or Seminole Rock controlling deference, that if you find ambiguity in this regulation, then you should defer to our reasonable interpretation based upon our consistent approach to this regulation and the reasonableness of the interpretation. The reasonableness of it is grounded in the fact that the Armco Court basically construed the very same language the same way that we are asking you to construe it today. So, Mr. Austin talked about whether Armco is a precedent. I'm not suggesting it's a controlling precedent. I'm not saying that only an en banc court, for example, that you would be overturning Armco. I understand it was dealing with the prior regulation.
Answer briefly what is between Rhino and Wildcat. Why did you latch on to Rhino as the liable employer, as between those two?
For the sole reason that Wildcat did not employ Mr. Rule for a full calendar year.
So, Mr. Doyle, let me ask you this then. Do you agree with Mr. Austin, if we were to apply Shepard, and I know you're in stark disagreement with that, but if we were to apply Shepard, do you believe it should just be remanded in order that it's the trust fund? Or and I thought I was following your brief, to be candid with you, about the question of financial solvency.
Yes.
And to your credit, you admitted there was error about the successor liability. You just said it was harmless. Do you agree with Mr. Austin then if we were to apply Shepherd that there's no need to remand it? Or do you think that there has to be a remand to allow the ALJ to address financial solvency?
I don't think there should be a remand, but I do think that the case should be resolved against Rhino on the financial solvency issue because the board did rule on that. The board did. The problem, Judge Novak, if you send it back to the ALJ doesn't have any evidence whatsoever about Wildcat's financial solvency, right? And no party at this point can produce that, is permitted under the regulations to give that evidence to the ALJ. So the ALJ can't make a finding of fact about the financial solvency, except to say that Rhino did not prove that Wildcat had the financial resources. So this is really a legal issue about who had the burden of proof. It's our position, the director's position, that Rhino had the burden of proof before the ALJ. Ms. Scarberry's position is that it was our burden because the district director did not include a certificate or a statement within the record as to
You're saying that Rhino bears the burden to shift the liability, and that Rhino had the burden to establish Wildcat's financial status?
That's correct. At the time that the case went to the ALJ, the director's burden was to show that Rhino, not Wildcat, but Rhino was a potentially liable operator. Rhino admits that it is a potentially liable operator. Under the regulations, the burden then shifts, and this is very clear from the regulations, Your Honor, the burden shifts to Rhino to prove that Wildcat or any other potentially liable operator had, among other things, the financial resources to pay the claim.
You're saying that it was clear that Rhino was a potentially liable operator.
Yes, and they admit as such, and they admit as such in their appellate brief.
And then you're saying, once it's established that a company is a potentially liable operator, if it wants to bring another operator into the picture, the way it should do that is by establishing the criteria, including financial status and financial solvency. And you're saying that in shifting, where you have met your burden in clearly establishing someone's status as a potentially liable operator, the burden then shifts if that one you established wants to finger another operator and say, no, it's their responsibility. You're saying you have to say why. You have to say why. And you're saying that isn't what they've done now. Does this, in your view, swing free and clear of the result that we might reach under Shepherd and under Baldwin?
Yes, Your Honor. If you find that if you uphold the board's finding with respect to the financial solvency, that would end the case. It would require an affirmance of the board order, free and clear of the 1 year issue.
And because the 1 year issue is not in the case, is it? I mean, it's been.
It's in the case to the extent that, yes, we've talked at length in the Baldwin case, but, here Wildcat.
But it's clear that Rhino has both the ability to pay and that it has employed the miner for at least a year and that the miner worked at least 125 days for that year.
Right. There's no question as to Rhino meeting the 1 year requirement. The question is whether Wildcat.
Saying that those three criteria have been established that Rhino has the potential, has the financial ability to pay the benefits. It's also clear that Rhino has employed the minor for a year. It's also clear that the minor worked at least 125 days during that year. So Rhino's status is established, and once Rhino is established, then Rhino has a burden which, in your view, they fail to meet. And just affirming the director on this point would have the benefit, I guess, of allowing the minor, in this case, to know that benefits were due him and that Rhino would pay them. So it would facilitate, more so than a remand, a definite resolution of this case so that this minor will get his benefits from Rhino.
I think that's correct. I think my understanding is that the minor is getting the benefits from the trust fund during this whole process. Mr. Austin could correct me if I'm wrong, but
I know that he's going to get paid, and it's going to come from the trust fund. But you don't want to be in a position of just raiding the trust fund willy-nilly.
absolutely.
In other words, I'm hesitant to say, oh, well, this can go to the trust fund, this can go to the trust fund. Because the very reason for the trust fund is if there's no potentially liable operator, is if you don't have anybody else that can pay it. The trust fund is a backup, but I don't know that you don't necessarily need the trust fund if you can establish the criteria that Rhino has for being a potentially liable operator, and Rhino has not carried its burden that then comes in to shift responsibility to another party. And I gather that's the path of analysis that you want to pursue. I just want to make sure that I am hearing you correctly.
You are, Your Honor, and there's one other, Ms. Scarberry's argument is that under subsection D of the regulation, the fact that we did not include a statement in the record as to Wildcat's financial status means that there's a presumption that Wildcat is financially viable. But our argument against that is that if you read the regulation, subsection D, that conclusion only comes into play if the reasons include the most recent employer's failure to meet the conditions as to the financial ability to pay. That was not one of the reasons that the district director relied on, and therefore the consequence that there's a presumption the Wildcat is financially capable of assuming the liability does not come into play. So that's where that issue is joined as to the meaning of that subsection. It's 495D as in David.
Mr. Doyle, can I just ask you this? I just want to make sure I understand this.
Yes.
Again, I know you disagree with the Shepard application, but let's say Shepard is applied. When I looked at the ALJ's opinion, there is no reference at all to financial solvency. Right. I understand, Mr. Austin's right, the minor's going to get paid. The question is speed a little bit, but it's also who pays, right? And I think what Ms. Scarberry is saying is Rhino ought not to pay because your director wrongly applied the rule, and it sounds like I might agree with that in terms of Shepard. But you're now saying we need to say that financial solvency saves the trust fund from having to pay, and that Rhino's still on the hook. My problem with that is I see nothing in the record addressing that. And before we can say that Rhino is liable to pay, shouldn't we have something in the record that we can hang our hat on? And particularly when it's the director's responsibility, as I understand it from the regs, to make a certification, either that they have insurance or that they're self-insured and they have, referring to Wildcat, or they have the financial ability to pay. And the record is devoid of that. And I'm very nervous about having a coal company having to pay for something when there's nothing in the record that addresses what is the decisive point from your perspective.
Right, I think, I disagree with the statement that you made that we had the obligation to put that statement in the record. And I will point to a case that we cited in our brief at page 6, I believe, the Marfo Coal Company versus Weiss. It's an unpublished decision from this court, but it was a similar circumstance under which the named coal operator was arguing at the administrative level that it shouldn't be on the hook, and when it did not bring the evidence to the attention of the district director. The financial evidence that you're talking about that should be in the record was the obligation, it was Rhino's obligation to bring that evidence to the district director when it was before the district director.
But how did
happened.
they do that? I mean, it seems to me, though, that I think Ms. Scarberry's right, that the director has access to Wildcat's financial status, whereas Rhino does not. The director has in its files the insurance, the self-insured, and the solvency. Rhino doesn't know that about another company, would they?
It depends. There's subpoena power. There's discovery, availability of discovery to determine those things. But that's something that's in the regulations, Your Honor. That shift of the burden of proof is very clearly set forth in the regulations, that it is the responsibility of the operator to prove the other operator's lack of financial resources.
Well, I think Ms. Scarberry disagrees with you on who's got the burden there, but I think my point is not to resolve that, but to say, should not the ALJ have decided that, gone through that analysis to allow us to make the decision on financial solvency before we put Rhino on the hook for paying this when there's nothing in the record to do it? I'm sorry, Judge Wilkinson, for going past the time.
No.
If I could just comment briefly, Judge Wilkinson, if we send it back to the ALJ is not going to have any evidence about the financial wherewithal, and it's not going to be able to get it. And so the question is, whose obligation was it to bring it to the district director's attention? And I would suggest to you that the Marfo Coal case will answer that in our favor. Thank you, Your Honors.
Well, let me ask you, read me the section in the regulation that says that this is Rhino's burden.
So it's 20 CFR 725-495, subsection C as in Charlie. And this is talking about once the case is moved to the administrative law judge level, the designated responsible operator shall bear the burden of proving, and again, they were the designated responsible operator, so they had the burden of proving either that they did not themselves possess sufficient assets to secure the payment of benefits, or that it is not the potentially liable operator that most recently employed the miner, which in this case they would argue Wildcat was, and such proof must include evidence that the miner was employed. I'll go on. In order to establish that a more recent employer is a potentially liable operator, the designated responsible operator must demonstrate that the more recent operator possesses sufficient assets to secure the payment of benefits.
So your view is that the regulation clearly, once you've established Rhino's potentially liable operator status, your view is that the regulation you just quoted does very clearly put the burden upon Rhino to establish that someone else should be on the hook.
That's correct, Your Honor.
And you rely on the regulation for that. Is that Judge Novak raised an interesting question. Is that an impossible burden for Rhino to discharge?
I don't believe so. I think, I will point out that this was challenged in the D.C. Circuit when it was first promulgated, the National Mining Association case. The D.C. Circuit upheld the regulation. But I will say, no, it's not in any commercial dispute. There can be third-party discovery to figure out the financial wherewithal of another entity. So, it may be a difficult thing to do, but it's certainly not impossible.
All right. Judge Floyd, do you have any further questions? Judge Novak, do you have any?
Thank you, Judge Wilkinson, I'm fine.
All right, let's go, and Ms. Scarberry has some rebuttal time here, and we'd be pleased to hear from you, Ms. Scarberry.
Thank you, Your Honor. One important point I want to make here is that obviously Rhino Energy's status as a potentially liable operator has been established. However, the analysis does not begin or should not begin with an earlier operator. It should begin with the most recent operator. And the regulations require that the more recent employer who employed the miner for 1 year or more should be named. In this instance, that's Wildcat Energy. The director now wants to argue in their proposed decision and order and their schedule for the submission of additional evidence, which were early pleadings at the district director level. They only listed as their reason for naming Rhino as the lack thereof of meeting 1 year of employment. It applied the incorrect standard. They at no point argued inability to pay. In fact, before this court is the very first instance in which the district director has argued that Rhino Energy cannot establish a Wildcat has the inability to pay. That burden is on the district director. The district director is required by the regulations to specifically and thoroughly explain all of their reasons. The statute specifically says must explain their reason or reasons as to why they have named an earlier operator as opposed to a more recent operator. Here, they only listed year of employment. They did not list inability to pay. If that was in fact a reason, then both of those reasons should have been listed. They also argue that Rhino is not a successor operator. If that is a reason, then that should have been listed as well. The district director failed to do their due diligence and meet their burden. And now they want to pass accountability onto the employer, as Judge Novak pointed out. Legal conclusions are de novo review, Your Honor. As Mr. Austin and as Mr. Dole have indicated, I don't think remanding this case back to the administrative law judge is going to resolve any of these issues because these are legal conclusions, Your Honor. A determination of whether Wildcat Energy is a responsible operator is a finding of law. And whether or not they have the ability to pay is a finding of law.
But you're not, the one thing it seems to me that, that people are united on is that they don't want another remand. You're not in favor, I know that Mr. Doyle was not in favor of a remand, and you don't want another remand either, do you, Ms. Scarberry?
No, Your Honor, I don't think any of us do. I think that's because reopening the record and remanding this case isn't going to resolve these issues. As Mr. Austin pointed out, you're going to get the same result. And that result is that Wildcat Energy is the more recent operator to have employed the miner for 1 year or more.
So, Ms. Scarborough, in your case, we would just reverse for payment of benefits.
Your Honor,
if we write the opinion, we just reverse for payment of benefits.
Your reversal would be the finding that Rhino Energy is the appropriate responsible operator. When you reverse that decision, determining that Rhino is not the most recent operator to have employed the miner, then the case is automatically transferred to the trust fund because they incorrectly named the wrong responsible operator for this case.
Again, it's reversed for payment of benefits.
Yes, payment of benefits has not been contested. All of the parties agree that the claimant is entitled to benefits in this particular case. It's just who's going to pay. So the current finding is that Rhino is to pay. If you reverse, it's a trust fund case, Your Honor. Another point I would like to make is that the director also indicated the availability of discovery, placing this burden on the employer. The employer is essentially given 90 days to respond to any findings that the district director has listed in their pleadings. Here, the district director only listed one reason. It didn't list all of the reasons that should have been listed. And this is a slippery slope, because if the director's argument is given merit, then this creates a very dangerous situation, as if in future cases the director would fail to list an inability to pay as a reason, because then that would call into question the 495D statement. I see my time is about to end, Your Honor, if I just may briefly conclude.
Do you disagree with Mr. Doyle's interpretation of the regulation here as regards the burden?
Yes, Your Honor, I do disagree. I believe that the regulation requires the district director to bear that burden. Here, the district director did not fully carry out their burden.
How can that be squared with the language that he read?
Your Honor, that's only when the case is transferred to the Office of Administrative Law Judges. When that case is transferred, then the employer or the subsequent operator then is required to rebut that presumption. But we've done that. We've done that through the regulations themselves, because the regulation specifically has a presumption which says that if the district director didn't do what they were supposed to do, then they're on the hook. And we have relied upon that regulation, which is obviously the framers of the regulations intended for us to do. I see my time has ended. Thank you, Your Honor.
We thank you. All right, I will ask that we appreciate all of the counsel in this case, and thank you all for your arguments. I will ask the courtroom deputy, and thanks as well to the courtroom deputy, and I will ask her to please adjourn court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.